Yes, artificiality, I think you said your next heading was.
Yes, although, my lady, I think we must probably now call it, after this morning, absence of purpose rather than artificiality. The point that my learned friend made was that the works must have some purpose beyond getting rid of the tenant. And she sought to draw an analogy with the tax avoidance cases built on furnace and so forth. And my lady, typically those authorities involve a two-stage transaction in the context of a statute, the evident purpose of which, according to the statute, is to get tax in for the taxpayer, but the purpose of the two-stage transaction being to avoid that very purpose. So that's the typical tax avoidance model. And in our submission, that has no relevance to or comparison with the situation your ladyships and lordships are confronted with here. There is no two-stage transaction here. I don't say it identifies into ingredients that straightforward, but there is no two-stage transaction here. There is no intention to avoid a liability under the statute, as there is with the tax avoidance cases. Unlike the case confronted by the court in Arrowtown, there is no relevant intermediate disposal to which one should not give effect. And the overriding point, which I think I'm probably repeating, is that it is easy to judge the absence of purpose in tax avoidance cases, but there's no easy comparator here.
Why is that?
Well, my lord, that goes back to the objective-subjective point. And I'm sorry to harp on demolition, but it makes my job easier. In the case of, let me paint this point by reference to the facts of an actual case, my lord, just to make it easier. If your lordships take up bundle 1 and look at tab 7, page 601.
Sorry, 6.
601.
Thank you.
Another case in the Court of Appeal in 1966, Housley's and Bloomer Holt. And I can just take the facts from the head note, the last paragraph on the first page. The tenants applied for a new tenancy. There was unchallenged evidence before the county court judge that the landlords intended to demolish the only buildings on the tenant's holding, namely a wooden garage covering 1/3 of the holding, an open cinder-covered space and a brick boundary wall, and to concrete over the whole site to make an entry, exit and turning space for heavy lorries coming to and from their timber yard to meet the requirements of the planning authorities. And the county court judge said that the landlord's real intention was to obtain possession of the tenant's holding, and it went on appeal. And can I just finish this recitation of the facts by showing your lordships what actually happened by reference to the judgment of Lord Justice Diplock at page 608. Last paragraph on that page, he says, with regard to the substance of the appeal, the judge seems, I think, to have been largely influenced by the short-lived fallacy in the judgment of the Court of Appeal in Atkinson, which seemed to suggest that one had got to look and see what was the primary purpose or motive, intentional purpose or motive of the landlord was, and so on. Now, back to the facts. So really, what one's looking at for the purposes of section 31F is the works to be carried out to the premises in the holding. The premises in the holding here were just the garage, the cinders, and a brick boundary, so a relatively minor part of quite a large area of land. Now, pausing there, my lords, if that was the situation confronting the county court, and in the new world, which my learned friend is inviting your lordships to hold is the world that should be appropriate for these purposes, applying an objective test, what is a judge to do? This is not a case of, is the purpose of this to avoid tax, but applying an objective test. What question is to be formulated? If the test is subjective, why do you want to do these works? Then that brings motive straight back into the equation, which is something that has been stamped on by every single court that's ever adjudicated on this point. You simply look at the 231F ingredients. So that's where I say, my lord, the tax avoidance analogy breaks down, because whichever test you apply, it's not as simple as saying, well, this is simply trying to get round the protection in the 1954 Act. The balance in the 1954 Act was to allow tenants to stay in possession of their premises unless the landlord could prove a ground of opposition. And in proving that, the landlord simply had to satisfy those two ingredients. There was never any question of the landlord proving why it wanted to do the works. Now, it's appropriate at this stage, my lords and my ladies, I think, to invite your attention to Jones and Rootham Park, which was a case bearing some similarities to this. And rather than take, well, if your lordship still have bundle 1 open, it's the authority at tab 8, starting at page 611. So it's called Wentworth Securities and Jones, sub-nom Jones and Rootham Park, and it concerned one of a great number of houses on the Rootham Park estate. And what happened here, as the head note shows, your ladies and lordships, was that the tenant wanted to serve a notice to enfranchise the tenant's house. And then reading just below letter E, before the notice was served, the freeholders granted a concurrent lease to a property company, the reversioner, for 300 years, subject to the existing lease at a peppercorn rent and until the expiry of the tenant's lease and at a rack rent thereafter. Can I then invite your ladyship's and lordship's attention over the page, the top of page 612, 4 lines down, after finding that the concurrent lease was a device to increase the value of the freehold, so increasing the price that the applicant would have had to pay, the tribunal held that section 23(1), which is the anti-avoidance provision in the 67 Act, was not applicable to the concurrent agreement as the tenant was not a party to it, and that the agreement did not modify the tenant's rights nor impose any penalty or disability. Therefore, the tribunal determined that the tenant should pay £4,000 to the freeholders and need not pay any sum to the reversioner, and so forth. And the evidence had been that if this was a device which should be ignored, the price payable would have been £50 to the freeholder and £250 to the reversioner. So there was a big difference attributable to the freeholder's decision and whether that worked or not. If your ladyships and lordships then go to page 642, judgment of Lord Diplock, and we quote this in the 4th appendix to our written case, but here it is. Between letters C and D, Lord Diplock says, "My lords, it would seem most unlikely that either the draftsman of the Leasehold Reform Act 1967 or those members of either House of Parliament by whose votes it was passed had envisaged the possibility that any ground landlord would enter into an intermediate lease in the precise terms adopted by Wentworth and Rootham, or in any other terms which would have had the same economic consequences as between ground landlord and intermediate tenant. If it had been envisaged, it seems likely that the draftsman would have done something about it to prevent its having the effect of enhancing the price payable by the resident tenant for the freehold. But how he would set about achieving this and what words he would have used to do so is a matter of pure speculation. My lords, I'm not reluctant to adopt a purposive construction where to apply the literal meaning of the legislative language used would lead to results which would clearly defeat the purposes of the Act. But in doing so, the task on which a court of justice is engaged remains one of construction, even where this involves reading into the Act words which are not expressly included in it. And he refers to Cavendish, and he says just under F, but in that case, the three conditions that must be fulfilled in order to justify this course were satisfied. He sets them out. First, it was possible to determine from a consideration of the provisions of the Act read as a whole precisely what the mischief was that it was the purpose of the Act to remedy. Secondly, it was apparent that the draftsman and Parliament had by inadvertence overlooked and so omitted to deal with an eventuality that required to be dealt with if the purpose of the Act was to be achieved. And thirdly, it was possible to state with certainty what were the additional words that would have been inserted by the draftsman and approved by Parliament had their intention been drawn to the omission before the bill passed into law. Unless this third condition is fulfilled, any attempt by a court of justice to repair the omission in the Act cannot be justified as an exercise of its jurisdiction to determine what is the meaning of a written law which Parliament has passed. Such an attempt crosses the boundary between construction and legislation. It becomes a usurpation of a function which, under the Constitution of this country, is vested in the legislature to the exclusion of the courts. So that's Lord Diplock. Lord Salmon adds a few words which I should briefly show to your lordships and ladyships on the same page, just below letter F. He says this somewhat odd, possibly unique, and certainly ingenious transaction was not a sham, it was a reality. It was, however, admittedly a device to discourage the tenants from acquiring the freehold of their homes by exercising their rights under the 1967 Act. And at the bottom of the page, last paragraph, in my opinion, it was clearly the policy of the legislature under the Act of 1967 that the tenant should obtain the freehold of his home at the ordinary market price, and not at a price which had been inflated by a transaction such as the present. I have no doubt that if it had ever occurred to the legislature that a transaction such as the present might have been devised and put into operation, clear words would have been introduced into the Act which would preclude such a transaction from affecting the market price which the tenant would have to pay for the freehold of his home. As it is, no such words appear in the Act, and accordingly it contains a gap. The courts have no power to fill in any gap in an Act, even if satisfied that the legislature would have done so. So, taking Lord Diplock's three ingredients, my lady, my lords, I say that in the first place, Learned Friend is simply unable to say that the mischief at which the 1954 Act was aimed was landlords being able to get rid of their tenants too easily. She can't say that. All she can say is that the mischief at which the Act was aimed was that which appears in the long title to the Act, which your lordships and ladyships have in the bundle. It was to strike a balance between security of tenure for tenants and the landlord's ability to recover possession of their premises in appropriate circumstances. And to find out what those appropriate circumstances are, one looks to 31F and the ingredients in it. And it is an argument that proceeds to pull itself up by its own bootstraps to say, well, it must have been intended to go further than that. One cannot say that by looking at the words of the Act. And one absolutely cannot say that by looking at the pre-legislative material, because that, if anything, shows that Parliament considered points like this but decided not to draft them in. So that deals with the mischief. If we can't ascertain the mischief in the way suggested by my learned friend, then we don't even get to the second Diplock ingredient. And even if we get beyond that, how can it possibly be possible to state with certainty what were the additional words that would have been inserted by the draftsman? And that is the point that I think I've probably said more than a few times. So we accept that the mischief was landlords turning out tenants and benefiting from their fit-out, but we also say a balance had to be drawn with the landlord's interests in redeveloping without any restrictions being put on that by 31F, apart from those two ingredients which I've mentioned more than once. So that is the balance struck by the 1954 Act against a background of Parliament expropriating property rights. the tenant can apply to renew and the landlord can oppose on the 31F grounds. So those are my points on artificiality or purpose. It starts by assuming that which it sets out to prove by saying, well, it's not working, this act, if the landlord can simply move in and carry out lots of works which have no purpose to them other than to get rid of the tenant. If Parliament had been intending to call that a mischief and then to deal with it, well, it certainly didn't, and it's very difficult to see how it can formulate a purpose to do so now. So I think that's probably a rather long way of answering my Lord Sumption's point. Why is this act different from the tax avoidance cases? And I say because you can put in one sentence what's wrong with an artificial two-stage transaction which avoids tax. The answer is, well, it gets around the whole purpose of the taxing statute. But there is no comparison in the case of the 1954 Act. You can't measure it in the same way. To find out whether a scheme achieves no purpose, it involves a difficult value judgment where it's not even clear whether the test is subjective or objective.
But the Lord Diplock's three-part test is essentially a test for implying things into the statute, whereas Furness and Dawson and Ramsey did not purport to imply anything into the statute, but simply to analyse the transaction to which the statute applied in a way that enabled the statute to have its manifest effect. And that, I think, is what is the suggested analogy in this case. I mean, there's a separate point, and I see the force of that, that this particular act has purposes more complex than simply to protect the tenant. I see that, but I'm not sure you are reinforced in that point by Lord Diplock's analysis in Jones and Rushton Park.
Yes, my Lord, I understand the point, but nevertheless, the same principle applies. If you do say, well, let's apply a purposive construction to the statute and identify what test to apply beyond the simple wording of 31F, you're still grappling with the same problems that Lord Diplock identified in Jones and Rushton Park. You still have to come up with a satisfactory formula that can be used uphill and down dale in the county courts without creating a massive expense and difficulty, lengthening trials, and in the end, making landlords say, I'm simply not prepared to put up with that, I want a contracted out tenancy.
Yes, the basic problem surely is this. This wasn't a contracted out tenancy. So the lease that your clients acquired was burdened with the rights of the tenant under the 1954 Act. Now, one thing that Parliament seems most unlikely to have envisaged is that, not having invoked the option of contracting out of the 54 Act altogether, the landlord should nevertheless be at liberty, simply by paying the cost of the works, essentially to buy himself out by doing works that frankly had no useful function other than getting rid of the tenant. It is simply a way of paying money to be rid of the rights of the tenant under the Act. Now, I can see the force of the point that you've got to be satisfied, not just that Parliament didn't intend that, but that it intended something else instead. But Parliament clearly did not intend that.
Well, your Lordship's able to be clear about the point, but, my Lord, it's difficult to say why that should be so. Your Lordship says it's difficult to see why a landlord should be able simply, by putting forward an artificial scheme, to get rid of the tenant. There's nothing simple about that, my Lord, with respect. Any 54 Act case where a landlord relies upon 31F is immensely complicated as it is. The landlord has to put forward a scheme. It has to show that it's got planning permission so far as it's needed. It has to show that it's resolved to do it. And it has to show that it's practically feasible from every point of view.
But if the works achieve nothing other than the removal of the tenant, then effectively what's happening is that the works are irrelevant. It's simply the payment of a sum of money to get rid of the tenant.
Yes, my lord, and
You accept
yes,
that?
I accept that, and my lord, I add the point, what if the landlord in this case actually was motivated by a desire just to have a set of premises with a lower floor and with all the other works done? Perfectly feasible. Why would that make any difference to your lordship's analysis? I ask rhetorically. So, and one can apply that to any set of circumstances, to the demolition set of circumstances. Why would it make any difference that the landlord in Housley's and Bloomerholt wanted to demolish the garage, covering a third of the plot, just to get the tenant out, knowing that that would work? Why does his purpose in doing it make any difference at all to the statutory framework? And that's the question, Mike. I don't say that to be difficult. That's a very, very difficult question. And there's no guidance to how one answers it at all in 31F. That contents itself with just dealing with, do you intend to do the works and are they substantial? Not what your motive is. So your lordship is right to draw attention to the difficulty in this case, that the works were designed with the aim only of getting the tenant out. But what if they hadn't been? It wouldn't
Well, if they hadn't been, many of the criticisms that have been advanced by your opponent would clearly not have been good ones.
But, my lord, that's precisely my point. My point is, why should it make any difference what the personal motivation of the landlord is? Your lordship's point is, well, this is an abuse of the Act, in effect, because the landlord can, by just paying money to do works, get the tenant out. My rejoinder is, so what? That's what always happens with 31F. But in adding an extra layer of what's the purpose of the work, why does the landlord want to do it, that doesn't advance the tenant's protection. Landlords from now on, I suggest, my lord, given these sorts of circumstances, will simply add to their resolution, not, and I want to do these works to get the tenant out, they will be saying, I want to do these works because I want a lower basement because that'll give me greater headroom. There will be an alteration in the way landlords approach projects like this. It so happens that the landlord in this case was transparently honest about its motivation for doing the works.
It's obvious that in other cases, the fact-finding task of the county court judge may be more difficult than it was in this one.
Yes.
The point doesn't go much further than that.
No, well, my lord, it does to this extent with respect. It doesn't advance the tenant to any degree at all to say that there must be an additional layer, a third ingredient in 31F, namely the landlord must have a purpose to doing the works beyond getting me out. Because landlords will come up with reasons, bound to. And without telling lies, my lord, but in this case, the landlord could have said, and in fact its witness did say, the purpose of doing this long term is to make sure I've got a clean run when I want to redevelop my hotel. And by the way, I do want 2 retail units at the front. I can't complete those works yet because I need planning permission for it, but that's my scheme. So it will be very easy in my submission for landlords to say, all right, I've got to put up with an extra day's worth of cross-examination in court as to the purpose for which I'm doing these works, but I'll come up with something. And what's that done to the tenant's protection? Precisely nothing. What's it done to overall relationships between landlord and tenant? Well, it's driven up the expense of hearings. And what's it done overall to business tenancy occupation? I suggest it will make it more likely that landlords, in granting future tenancies, will just want them contracted out. As it is, landlords face big hurdles in devising schemes for 31F. And if your lordship's allowed this appeal, it may well be that will be the trigger for unintended consequences, namely landlords saying this is just too much like hard work and will contract out. It's terribly easy.
They may not get the same rent.
Possibly, my lord, possibly. My lord, the last point I wanted to make before finishing this is another thing that illustrates the difference between tax avoidance statutes and property statutes, and that comes out of the judgment of Sir Thomas Bingham in Belvedere. And rather than take your lordships to the judgment itself. Can I simply refer your lordships to our extract from it at Appendix 4 to our case. So it's...
So where do we find it in the authorities?
I'm so
rather
sorry.
than in your, where do we find it in the authorities rather than in your case? You can assume we've read your case.
Right, yes, it's Bundle 1, Tab 4. I'll lay down very quickly.
Mine's tab 2.
Tab 2, yes, Tab 2.
It's not tab 4, is it?
Tab 2, I think.
Tab 2, page 493.
And the particular page?
Page 511. So, my ladies, my lords, the factual background to this is very complex, but essentially it was a tussle under the Landlord and Tenant Act 1987. From Sir Thomas Bingham's judgment just below letter C, he says it would seem plain that the object of Frogmore was not primarily to deny the tenants a power to manage, but to ensure that the profit to be made by selling long leases of the flats in the block was earned by Frogmore or Atherton and not the tenants. There would seem to be little room for doubt about Frogmore's motivation. I share the judge's view that these arrangements were not a sham. There was no element of pretense. The parties were not doing one thing and saying another. I would also accept the judge's view that the Atherton leases were an artificial device intended to circumvent a result the Act would otherwise have brought about. But the finding of such a device did not defeat the reversioners in Jones and Bruton Park, nor the lessor in Hilton and Plus title, and I'm not, for my part, satisfied that in the field of real property, the principles in Ramsey and Furness entitle the court simply to ignore or override apparently effective transactions which on their face confer an interest in land on the transferee. Many transactions between group companies may be artificial. That does not entitle the court in ordinary circumstances to treat such transactions as null. My ladies, my lords, that concludes my submissions on artificiality, and I was, before coming to the other ground, I was just going to set out my conclusions on ground 2 by reference to the appellant's reasons for success on that ground. The first one, which is for reference in paragraph 44 of the appellant's case, is the public interest. Well, that's now been abandoned as an ingredient. The second ground put forward by the appellant in support of ground 2 is that protection is rendered illusory if the appeal is not allowed. And what learned friends say in paragraph 46 of their written case, and perhaps I can just read this out, but the reference is, perhaps I'll just read it out. In the real world for which Parliament has legislated, landlords of commercial premises do not incur substantial cost, in this case over 776,000 plus VAT, on demolition, reconstruction or construction, which does not enhance the value or usefulness of their property, or which positively damages it. Well, my ladies, my lords, I say precisely, although I think we'd put in the word generally or usually in that sentence, we agree. And that is why this is self-limiting. It is an immense disincentive for landlords to put forward a scheme which doesn't actually increase the value or usefulness of their property. And it's probably, speaking rationally rather than by reference to authority, very rarely done for that reason. So the warning that learned friends go on to give in paragraph 46 of their written case is without any substance. If in the real world landlords do not incur substantial costs on such works, then how can the protection given by the Act be rendered illusory? And notwithstanding all that, learned friend feels able to assert that many landlords are likely to follow in the footsteps of this one. Well, I ask why. This test that we apply, the hallowed test under 31F, does not open the floodgates, and it hasn't ever done in the long history of the Act. Lastly, my lords, on this particular ground, I cited this morning the judgments of, the judgment of Lord Denning, Master of the Rolls in Decca Navigator, which is at tab 5 of bundle 1. And I'd just like to take your lordships also to the judgment of Lord Justice Stevenson. So the case starts at page 577. Lord Justice Stevenson's judgment is a very short passage at page 582. Just above letter E, says the question for the court is not whether landlords reasonable in intending to do the particular work defined in the drawing, but were they, having genuinely informed that intention, reasonable in dispossessing the tenants completely in order to carry it out. Could they, in common sense and in reason, have carried out that substantial work of construction without obtaining possession of the whole of the holding, or could they have carried it out while leaving the tenant in possession of the 15-foot wide strip? To that question, there can only be one answer, and that in favour of the landlords. It may be that landlords with Section 31A in mind will suit their intentions to the statute and deprive tenants of the chance of resorting to that section. Then the court will have to be satisfied that their intention is genuine. But if it is, the tenants will have to rely on other possible restrictions on what is still left of a landlord's right to do what he likes with his own. And my ladies, my lords, I say that contemplates the very arguments that are being put forward by the appellant in this case. And if that's what the statute says, then what is to stop landlords tailoring their works to suit the section? And I say, well, nothing now, just as there has never been since this decision in 1974. Has it happened in practice across the country? Well, not so far as we've seen any evidence of. So as to landlords evading the Act, it's not a question of evasion in our submission. It's something that properly advised landlords have always been able to do. And because of the limiting factors in Section 31F, as I say, the substantiality, the genuineness of intention they have to demonstrate, it's self-limiting. Next point, this is paragraph 47 of the learned friend's grounds. Parliament keen to avoid devices, and I can deal with this very shortly. Learned friend quite rightly points to the compensation provision in Section 37A if landlords get it wrong, the contracting out provision in Section 38, and learned friend tries to build on that, the proposition that it cannot sensibly have intended that landlords could build in a strict adherence to 31F. And I say, well, to the contrary. The Act requires that if landlords are going to rely upon this ground of opposition, they really must take the trouble to set out a foolproof case that's going to involve quite a lot of money. So they're not using a device, they're simply following through the correct construction of the Act. And then I come to my Lord Sumption's point about our scheme allowing landlords to buy out tenants. And with respect, my Lord, I say that overstates the case. All that 31F does is to give the landlord not a right, but the ability to put forward a scheme of works to the court, which the court may or may not accept, depending upon its assessment of the considerable hurdles that the landlord already faces under F. Paragraph 50, and the sixth ground the learned friend put forward, our scheme allows landlords to do unilaterally what they cannot do consensually. Well, again, in my submission, that overstates the case. Now, of course, following the 2003 Regulatory Reform Act, it's really very, very straightforward to contract out of the Act, one doesn't need to go before the county court and satisfy the registrar anymore that it's right that the tenancy can be contracted out. All one needs is a form served before the grant of the tenancy. It's as straightforward as that. So consensually, it's really extremely easy to contract out of the Act. And as I've said more than once, under Section 31F, it's really very difficult to succeed as it stands. Ground 7, this is a matter for the planners. Well, I've dealt with that already, my lords, my ladies. This is nothing to do with the planners, save in the sense that if the scheme requires planning permission, one has to obtain it. But the way in which the Act is to work is not something that Parliament ever thought fit to delegate to the planners. Eighthly, we have the conjunction between grounds F and G, and this ground appears to be founded on the premise that there should be no distinction between the way in which those two grounds work. And in our submission, they're two quite distinct grounds. And just because the court decided it was appropriate to subject ground G to the sensible limitation that a landlord must intend to occupy for a substantial time, that cannot mean that there should be any similar provision in ground F. Demolition is again the limb that proves that must be right. It would be ludicrous to require a landlord to be subject to a temporal element of any kind where it intends to demolish. And then the ninth and last ground is based upon major stake, and our case in relation to that was that to call major stake authority for the proposition that the works cannot be artificial is simply to misread the case, and I don't think I need say anything further about that. The court wasn't arriving at the view that the works in major stake were artificial, quite the contrary. It was merely saying that the question was, were the premises in which the flat is contained as red-lined by the landlord? And my lady, Lady Hale, may remember that Lord Justice Neuberger below canvassed the proposition that it would be sufficient for a landlord to incorporate a bit of corridor in the flat and say, well, that's the premises in which the flat is contained, or a box room. And your lady had no hesitation at all in saying that couldn't be right. So that's all that major stake does. And of course, the point I invite your ladies and lordships to take away from major stake is that substantiality was the key point in that case. The control mechanism for the works was their scale. Can I very briefly then, my lords and ladies, turn to ground 1, and I can make my submissions really very briefly in relation to this. This is the conditionality ground. The point, what I'm going to do is to provide some analysis and then one authority, which in my submission bears me out. The analysis is this. In order for the intention under Section 31F to have consideration by the court, it can only occur at the trial. That's Betty's Cafes. It's not the date it serves at Section 25 notice. It's not any intermediate date. It's the trial date. And what the landlord has to do at trial is to prove that it's going to carry out works, and it can't do those works without the tenant delivering up possession. So that's the statutory framework. And if in the context of that statutory framework, the landlord says, I undertake to do these works, then that, in my submission, to the extent that the works could ever have been said to have been conditional upon the landlord obtaining possession, changes them completely in character. They are works which the landlord has said at trial, the determinative date, I'm going to do these works, and here's my undertaking to do them. And that is the long and the short answer to this point. There's no conditionality at all. Yes, the authority I was going to mention was the decision of Mr. Justice Neuberger, as he then was, in Al Malik Carpets. That's volume 2, tab 11, page 1303. And one needs just to look briefly through the head note at page 1303 this was a Section 31F case. It didn't actually get to trial because the case was compromised and the landlord recovered possession under the compromise. Subsequently, it did different works to those which were the subject of its application to court, or its appearance in court. And the tenant then said, well, I'm going to sue you for misrepresentation because you said you'd carry out some other works. So that was the focus of the matter in court. And as one sees from just the middle of under the middle of the page, introduced by the words, the court ruled, in Betty's Cafes, it was held that where an application for a new tenancy was opposed on the basis of the landlord's intention to carry out new works of redevelopment, the landlord's intention should be determined at the date of the hearing. The intention was therefore conditional upon the tenant pursuing his application. If, as in the instant case, the tenant negotiated a settlement of the proceedings, it did not follow that the landlord was under an obligation to carry out the works. Thus, the statement of intention in the witness statement was not a representation and was insufficient to found the cause of action. And can I just go into the judgment very shortly in one paragraph at page 1314, where Mr. Justice Neuberger says, just under halfway down, there is another consequence of this being a case under the 1954 Act. All the landlord has to prove at the hearing is a bona fide intention to carry out the work in question. The reason for his intention does not matter. The defendant could therefore perfectly and properly have intended to put an atrium into the building in order to establish that he was carrying out sufficiently substantial work to justify denying the claimants a new tenancy, even though he would not have otherwise carried out the work. Indeed, it seems to me that that would be a perfectly good commercial reason for carrying out the work. It is quite logical to wish to carry out the work because it is justified commercially, as it will thereby improve the building and result in vacant possession. Whereas, if one had already got vacant possession, it would not be commercially worthwhile carrying out the work. Accordingly, it seems to me perfectly proper, as a matter of principle, for a landlord to say, I intend to do this work if and so long as the tenant is maintaining his application for a new tenancy, and if necessary, I will say in court that I intend to do the work, and that I will do the work, and if necessary, I will undertake to do so. However, it does not follow that if the tenant voluntarily goes, or if the tenant negotiates terms of settlement, I will still be obliged to carry out the work. So, my ladies, my lords, that in my submission provides a perfect fit for the submissions on ground one that we make.
Can I ask you to just look at that statement in the light of the way that this provision is structured? It's a condition of the right to refuse a new tenancy that the works could not reasonably, or that the landlord couldn't reasonably reconstruct the premises without obtaining possession. Now, to my mind, that suggests that the intention to reconstruct the premises has got to exist independently of the presence of the tenant, but the tenant's presence has got in the way of it, and therefore he refuses the new tenancy. Now, it appears to me one possible view of this is that applying your submissions to the facts of this case, the causation is entirely the other way around. There is no intention to reconstruct these premises independently of the presence of the tenant, and the tenant's presence hasn't got in the way. It's quite the opposite. The presence of the tenant has caused the intention to carry out the works to arise. And I do not see that that is consistent with the structure of 31F. I can see that the dictum of Mr. Justice Neuberger, as he then was, is to the opposite effect, but I question whether it could possibly be right, certainly as applied to facts as extreme as those of the present case.
I understand your Lordship's point. Your Lordship's point operates as if the word independently were inserted into 31F, or, if properly read, the words had that effect in any event.
The latter, I think, rather
Yes,
than the former.
yes. And my lord, I say with respect that that's just wrong. It's not the way that 31F has ever been interpreted in any authority. And it's directly contrary to what Mr. Justice Neuberger, a practitioner of unrivaled experience in this field, evidently thought in his judgment.
Why is it wrong as a matter of principle?
Because, my
I mean, I
lord,
quite understand that no judge has said this before, and that Mr. Justice Neuberger tends to the opposite view in that section. But why is it wrong as a matter of principle? Looking at the section.
well, Lord, it's not what the words, it's not the approach that the words of 31F invite you to take. They focus on what works are you going to do and can you do them. That's all. They don't invite some further determination of whether you would have done these works come what may. And by the time you get to court, that is not a valid consideration in any event. So, my Lord, it's immaterial whether in the real world the landlord would have done these works. The question for the court is always going to be, has the landlord proved he's going to do those works now? Not what else might he have done if the tenant hadn't been there. And if your lordship's right, that will invite yet further excursions in the county court about the real world compared to the transactional framework under 31F, with landlords having to prove what they would have done and that not being any different. It also creates phenomenal problems, my lord, with the case where a tenant has a genuine desire to do certain works. It's advised that given the hazards and the cost of litigation, it may as well dump in a whole lot of extra works, which will put the matter hopefully beyond doubt. How is the court then to analyse that, the augmented scheme? And a landlord might well accept that in the real world, if the tenant hadn't been there with a free hand, it might have done something completely different. But so what, my lord? What's that got to do with the statutory test?
Well, there are two possible answers to that. One is that if there is a discrete part of the works which are not proposed independently of the presence of the tenant, those would be disregarded. That was the solution put forward by Miss Wicks this morning. The other possibility is that you're absolutely right, and in that situation, you can't, so to speak, apportion the works between those which would be intended independently of the tenant's presence and those that would not. The third solution is that that's a complexity which we do not have to deal with on the particular facts of this case.
Yes, but my lord, it gets worse with respect. What if a landlord, take the facts of this case, the landlord wanted to lower the floor by some inches. Say the landlord's original plan provided in order to create more headroom, that's exactly what it would do. That's a cogent reason, it's got commercial purpose, it's going to be useful. Say the landlord is then advised that in order to make its case foolproof, it should get rid of the floor altogether. So no floor at all between ground floor and basement. What's the court to do in those circumstances? It may well arrive at the conclusion that that is, quotes, artificial or devoid of purpose or only to get the tenant out, but does it then conduct an inquiry into what the landlord would have done? And what if the landlord hadn't formulated the plan of what it would have done, but has got very cogent reasons for saying in court, well, if I'd realised that I'm not allowed to do works just to get the tenant out, then I would have done all this other stuff which I would have wanted to do anyway. So the hypothetical difficulty becomes really quite extreme, my lord, in those circumstances, and it's avoided completely if one adopts the orthodox interpretation of 31F. My lords, I'm really at the end. The points to which learned friend at the moment has no answer in my submission are really centred around the demolition ground. That, whatever one may say about substantial works of construction, the demolition ground, as I said when I was making my submissions on Housley's and Bloomer Holt, create phenomenal problems, because if you adopt a commercial objective approach to demolition, you're grasping with all sorts of imponderables. How will a court weigh up, without knowing what the landlord's motive was, whether this is a good scheme or not a good scheme, one which satisfies the test or doesn't, one which is just there to get the tenant out or not. But if you introduce subjective evidence about why the landlord actually wanted to do it, then you're into motive, and I say that's wholly impermissible on the authorities. So, my lords, my ladies, those are my submissions, unless I can be of any further assistance.
Thank you very much indeed, Mr. Featherstone Hall. Mr. Taggart?
I have nothing to add.
Thank you. Ms. Wicks?
My ladies, my lords, I shan't attempt to address every point that my learned friend has raised. Just pick out the most significant of those, and I'm sure if your ladyships or your lordships have any questions for me, you can please feel free to fire away. My ladies and my lords, starting first with the suggestion that that in a case of ambiguity, common law rights should be protected. This is where Mr. Featherstone started, and he relies upon it's the Re Wonderland Cleethorpes case, which is a case which was reversed on its ratio by the Law of Property Act 1969. In my submission, my ladies and my lords, the submission fails to reflect that when dicta refer to there being ambiguities or there being a plain meaning of a statute and applying a presumption in that case, that we no longer require that to mean a literal construction of a statutory provision. That there are countervailing presumptions at play, including particularly that an act should be construed so as to prevent the legislative purpose being undermined or rendered ineffective. But also that the 1954 Act does significantly curtail the landlord's common law right to terminate tenancy, subject to certain exceptions, and that Ground F is not concerned with preserving the landlord's common law rights, but in my submission with protecting its legitimate interest and the public interest in redevelopment. And we see that because in this case, the landlord, in proposing to undertake Scheme 3, is not seeking to exercise its common law rights, it's seeking to utilise a statutory provision in order to prevent the tenant exercising its statutory right to renew its tenancies. It is in my submission striking that the landlord offers no policy justification at all for the reading of Ground F that it puts before this court. I will just touch very briefly on the attempt to depart from the statement of facts and issues by Mr. Featherstone Hall. It is, in my submission, clearly not permissible. That was a document that was carefully negotiated and agreed to reflect the totality of the evidence in the case, and it's completely inappropriate for my learned friend to try and cherry-pick some of the evidence or give evidence himself to contradict it. My ladies, my lords, there's some discussion about subjective and objective purpose or reasons, and I wondered if it would help if I slightly unpacked some of the issues which have been raised. To start off, we must recall that the court is only considering what is intended, not something that's actually done. So the landlord has to prove that it intends to do something in the future, that is, on the termination of the current tenancy. It doesn't actually have to prove that it has in fact done something. And in that respect, we are in slightly different territory from the tax cases because, of course, in those cases, the courts are concerned with transactions that have already taken place. The question which we say the courts should be asking is the sole reason why the landlord is proposing these works to get the tenant out? And addressing that question, the landlord will put forward a reason. For example, I want to win the Turner Prize, or I want a turning circle. And of course the judge has to evaluate the genuineness of the evidence put forward by the landlord using all the usual tools, which might include considering what a reasonable landlord would do in those circumstances. But if the judge agrees that the evidence is genuine and truthful, then if the landlord wants to win the Turner Prize or wants a turning circle, the landlord has a reason or purpose which is not solely removal of the tenant. In our submission, it is not then relevant to go on to ask whether another landlord or a reasonable landlord would make the same decision. There's a risk, we suggest, of confusing what the test is with the question of how it should be proved. My ladies, my lords, the pre-legislative material, my learned friend pointed to some redevelopment ground provisions in earlier legislation. In our submission, this is simply a rehash of the legislation by omission submission again. None of the formulations used in previous acts dealt with or addressed the case that we make. And this court has to look at the words that Parliament did use in the light of its policy and context, and not the words that it didn't use. On workability, my ladies, my lords, as I've already said in my opening, the courts already have to look at why, and might just why the landlord wants to carry out certain works. Just remind you lordships of paragraph 48 of Mr. Justice Jay's judgment, which makes this very point. That's in the core bundle, tab 6.2. And it's paragraph 48, page 291, my ladies and lords.
Sorry, which tab?
It's tab 6, then Roman 2, my lord, in the core bundle.
Or tab 2 of the appendix.
Yes.
291 anyway, paragraph.
Paragraph 48. So obviously Mr. Justice Jay was accepting the landlord's position about the construction of Ground F, but nevertheless saying the why question may be highly relevant to the what and whether questions, because it's capable of illuminating the issue of intention. Briefly on the question of artificiality and the absence of purpose. My ladies, my lords, my learned friend characterised the Ramsey tax cases as typically involving a two-stage transaction where one stage was inserted to avoid tax. In our submission, he's confusing the two elements of the Ramsey cases. So what is made clear by UBS and other cases is that the breakthrough in the Ramsey case was on two levels. The first was the requirement that an Act of Parliament, even a tax act, should be construed purposively. And the second was that facts should be viewed realistically. In this case, we particularly refer to the tax cases because of their emphasis on the purposive nature of the construction of the statute. We don't struggle with the problem about viewing the facts realistically because we have an admission, which means that it's not as complicated as some of the tax avoidance schemes. My learned friend asks why it should make a difference if in another case a landlord wished to carry out exactly the same works as Scheme 3, but for some good reason, some good commercial reason. First of all, that seems highly unlikely, but in any event, that the reason why it makes a difference is that because carrying out Scheme 3 for the sole reason of getting the tenant out is not consistent with the policy of Ground F, and because it undermines the protections which the 54 Act gives the business tenant, and for all of the other reasons that we've set out in our written case. My learned friend, in this context, took your lordships to the Belvedere and Frogmore case, which is Authorities Bundle 1, Tab 2. And took your lordships to a passage page 511 of the bundle. I submitted to your lordships in opening that it needed to be borne in mind that there was a period of time in which the Ramsey cases were not properly understood, and they came to be clarified later. The first such clarification by the House of Lords was in Inland Revenue Commissioners and McGuckian, but importantly, they were significantly clarified by Barclays Mercantile and Mawson, which wasn't decided until 2004. So in 1997, when this Belvedere and Frogmore case was decided, there was still a lot of lack of clarity. And we see that in the way in which the Ramsey point is dealt with in this case. If I can take you back to page 496 of the bundle, please, page 861 of the report. In the argument of Jonathan Gaunt, Queen's Counsel, and Anthony Radevsky for Frogmore, you'll see at letter F on this page, there is no principle of property law which enables the court to ignore a transaction which is not a sham. A different principle applies to tax avoidance. See Ramsey. So the submissions on the part of Frogmore were tax is different. Then the submissions...
Well, there's a difference between being asked actually to ignore, virtually undo, a completed property transaction.
He was, but, my lady, in my submission, we don't have any problem with the ultimate conclusion in this case. Let me make that absolutely clear. The decision was that the nature of the transactions constituted a disposal within section 16 of the Act, and therefore there was an express provision of the Act dealing with the events which had occurred. My point is that some caution needs to be taken to the way in which Sir Thomas Bingham refers to the Ramsey approach in the passage which my learned friend took you to. And it's not really because it relates to property transactions, but it's because there's no clear understanding of the difference that I drew to your lordships and ladyships' attention between the no commercial purpose test and the no commercial effect test. So, as I submitted to you to the court this morning, the reason why in the Ramsey cases transactions are disregarded is not because they didn't happen, it's because they're treated as irrelevant. And a transaction could be a property transaction. For example, my Lord Briggs may remember a relatively recent Project Blue case involved a stamp duty land tax.
Not the only person who remembers Project Blue.
My lady, I do apologise if I suggested you weren't involved with that. But
We
by
talk
way
of
of
little else in the Hale household.
But for example, in that context, it might be a property transaction that falls to be disregarded because the property transaction, which might involve the transfer of title, legal or beneficial title, because the relevant statute says it is to be disregarded because it is being carried out for no purpose other than the avoidance of tax. So, in our submission, the Belvedere court case doesn't assist and needs to be treated with caution because it doesn't indicate a proper understanding either in counsel, and I didn't take your lordships, but to the bottom of page 497 we see Belvedere's counsel, very eminent counsel, including David Newberger, Queen's Counsel, right at the bottom of page 497, their submissions appear to equate the Ramsey principles with a sham. So they say, on general principles, the leases were a sham, and then refer to Ramsey, Furness and Dawson, etc. Whereas what's quite clear from the modern authorities in that line is that those cases are not concerned with shams. They are concerned with real transactions that do happen, that might include property transactions, but which are disregarded because a statute says that they are not relevant because they were effected for the sole purpose of saving tax. My ladies and my lords, just briefly to deal with the Al-Malik case. It is, of course, a first instance decision, albeit by a judge who went on to be very senior. But it is strikingly lacking, the dictum which my learned friend took your lordships to is strikingly lacking in any indication of a policy reason why it should be acceptable for a landlord to put forward a scheme of works just for the purpose of satisfying Ground F. In my submission, your lordships don't get much assistance from that particular dictum. Then demolition, I did cover this in opening. In my submission, there's demolition for good commercial reasons and there's demolition without good commercial reasons, and the court is well able to distinguish between them. My lords and ladies, on the conditionality ground, simply we say that the practical difficulties which my learned friends say will arise from giving the statute the meaning that we seek to give it are overblown, that one can always think of some extreme problem. Cases will have to be judged on their own facts, and Mr. Justice Jay, in giving the leapfrog appeal certificate in this case, considered one of the reasons why it would be suitable was that it was a particularly appropriate set of facts for this court to grapple with the issues that were raised. My ladies, my lords, unless there's anything else on which I can help you, those are my submissions.
It appears not. Thank you very much, Ms. Wicks. Thank you to everybody. We should thank Mr. Justice Jay for having leapfrogged this case to us, giving us the pleasure, therefore, of listening to your arguments and reading those. And thank you to everybody who's presented us with them. I feel quite sure that the juniors have played a part in that, even though we haven't heard from them on their feet today. So thank you all, and we will now go away and wrestle with the answers and report them back to you in the usual way.
Thank you very much.
Court will now adjourn.